All right, so in this case video, we're going to be looking at the Hawker Pacific case, which is a duress to goods case. So in this case, the helicopter charter company, they contracted with Hawker Pacific to repaint its helicopters, and it had 2 helicopters. I just thought that was a random interesting bit from the facts. Okay, so this company had 2 helicopters. It had contracted with Hawker Pacific to repaint one of them. Now, when Hawker Pacific painted the helicopter the first time, its manager was unimpressed with the quality of the job. And then as a result of that, the parties had actually renegotiated the price, and it ended up being a higher price. So obviously it must have been something to do with maybe the amount of coats required or something like that. I'm not sure. But in any case, so the price had actually gone up. The helicopter charter had taken possession of the helicopter, but when they saw the work, they were like pretty unimpressed, okay? And as a result of the poor quality of the work, they then re-delivered the helicopter to Hawker Pacific for rectification work, so for them to fix the works. When they came to pick up the helicopter, Hawker Pacific presented them with a document which had a new price listed for the works, which was lower than both of the previous prices, obviously for the inconvenience of having to bring a helicopter back to the place for it to be painted. And also it agreed, the document said that it settled the liability issue between the parties. So essentially by signing the document, a helicopter charter agreed to not sue for damages for the work, okay? Now, they signed that document that day because they needed to pick up the helicopter. They had chartered, the helicopter had been chartered for the next day. So that's why helicopter charter signed a document which was clearly disadvantageous to themselves. So the question that arose in the case was whether this duress to goods existed between the parties. And it was ultimately found that here the pressure was illegitimate, was unlawful. Okay, so helicopter charter was entitled to take the chopper away. Normally in these types of situations, if a person doesn't pay for a good, I didn't mention that, sorry, previously. A helicopter charter, when they picked up the helicopter, they obviously signed the document, but they didn't pay the amount at that time, and they didn't pay it later, the $4,300 or whatever it was that they owed for the repainting. Now, when looking at that issue of whether duress to goods existed, it was found that they were entitled to take the helicopter away. Normally, when someone doesn't pay for a good, the party who's done the work is entitled to exercise a lien over the good, so they don't have to give back the good until the money is paid for it. But here, because this was rectification work, it wasn't the original work that was done under the contract. Because it was rectification work, there was no lien in existence, which meant that it was unlawful for them to hold on to the helicopter. So here, the pressure was found to be unlawful, illegitimate. So that aspect of the test was met. What was interesting in this case is that at no point did Hawker Pacific actually say, if you don't sign this document, you can't have your helicopter back. So that's one of the things that we're going to look at in the case reading questions in a moment. Okay. And also, as I didn't mention this, but inducement wasn't a problem here. They signed the document because they thought that was the only way to get the helicopter back. Okay, so in terms of the case reading questions, so who sued whom for what? Okay, helicopter charter sued for damages for defective workmanship. And in order to do so, they needed to have that agreement that they'd signed set aside, because obviously that agreement was for the fact that they wouldn't sue on the basis of defective workmanship. So they needed that agreement to be set aside, and they were seeking to do so on grounds of duress. One of the things that I haven't mentioned yet that's important about the defective workmanship case, the reason why they wanted the agreement to be set aside wasn't just to do with the fact that they owed that $4,300 for the painting. It wasn't just that, it was the fact that in the course of trying to sue for defective workmanship, the question of damages had been referred to an arbitrator. And the arbitrator had found that the work done was not of a workmanlike manner, so the work wasn't up to scratch at all. And also they assessed damages at $20,000, okay, $20,000. So here it's not simply a matter of Helicopter Charter wanting to avoid the contract price, they actually wanted access to that $20,000. Now, in terms of the second question, in what circumstances did the letter come to be prepared and signed? When Helicopter Charter returned to pick up the helicopter after the rectification work had been completed, that's when the letter came to be prepared and signed. And because Helicopter Charter needed the helicopter for the next day, that's why they signed. Okay, so in terms of question 3, did Hawker Pacific have a right to keep possession of the helicopter? We covered that already. There was no lien here, and it didn't have a lien, so it didn't have a lawful right to retain the helicopter because the reason it was in the possession of the helicopter in the first place was to complete that rectification work at its own cost. Should have checked my slides before I started my recording. But you probably can't read this, but the question states, did Bartlett actually say he'd release the helicopter to Helicopter Charter if Huff didn't sign the letter? The answer to that is no. The threat was never directly stated. Okay, and then the second half of the question, what facts led the court to conclude that Helicopter Charter signed the letter under compulsion? Okay, so the main fact, I guess, to draw your attention to here is around the fact that the helicopter, it was needed that day, not the day after, as I mentioned earlier. So the helicopter was needed that day. Bartlett didn't make the threat directly, okay, as mentioned, but the circumstances were seen as such to justify the belief that this was the case, that if he didn't sign the document, he wouldn't be able to get hold of the helicopter. He believed that the only practical way of getting possession of the helicopter was to agree to the proposal, and that's why he did so. And the other party, when presenting the document, they were actually aware that the helicopter was urgently needed that day, so they were aware of those circumstances. In terms of the fifth question then, the case of Smith and William Charlick was an action to recover money paid under compulsion. Was Hawker Pacific and Helicopter Charter an action to recover money? No, it wasn't. Okay, it wasn't an action to recover money. Money hadn't been paid under the agreement. Okay. In terms of the second part of the question, why did the court say the difference didn't matter? The key areas, pages that you want to be looking at here is the Justice Priestley decision at 301, 302, where they discuss the Smith and William Charlick case, and also the Justice Clark decision at page 306. So here, the reason why the court said the difference didn't matter was because to make a distinction would lead to an absurd result. Okay, and you can see the quote at page 306 with regards to this, and where it states, on the other hand, the traditional view is that the detention or threatened detention of a person's goods is not duress, which will at common law enable the owner of the goods to avoid the agreement by paying it. This leads to the absurd result that if A paid money under duress of goods, he would recover the money paid, but if he entered into a contract to pay money under similar duress, he would be obliged to pay. Okay, so you see the similarities there. Essentially, it just means that the same result should happen whether Helicopter Charter had paid the contract price of $4,300, or whether they hadn't paid at all, which was the instance here. He should have access to that same result, that the contract could be set aside. All right, and that is Helicopter Charter case. And no, Hawker and Helicopter Charter, I've got this. It's Friday afternoon, I don't know. Anyway, we'll leave that there. Okay, thanks, guys.